Yes, students have done excellent work in this particular domain. As far as the awareness part is concerned, among the faculty members and in among the students also, especially the students of higher classes B and B, the awareness is there, and students are making it a point to register IPR, copyrights, as well as patents. Also, they have the initial information, and we are very much interested as far as the commercialization aspect is concerned. We are more focused on that, and our focus is on generation of revenue for the institute through this research and innovation. And in short, we say that it is Vidya to Lakshmi, whatever intellect we have, and that is to be converted in the form of IPR, and then further this IPR should be converted into uh, wealth. That is wealth creation through IPR is our tagline, and we wish to work on that. And in view of this, we have initiated this sale in particular under the guidance of Professor Dr. Mankar sir. Then Professor Bhavne is there. Professor Kishore Bhangare is there. All these people are there, and we'll be initiating few activities. And as a part of that, this particular activity has been arranged today. So we are very much keenly waiting to listen you regarding this particular aspect. And yes, ma'am, we welcome on behalf of our college, on behalf of our management, as well as all our students and faculty members, to deliver the session on IPR. I must congratulate Professor Mankar, Professor Bhangare, Professor Bhavne in particular, to take this initiative to arrange this session. And thank you very much for calling me to you can say deliver a welcome talk. So once again, I extend my best wishes for not only for the success of today's session, but for all the activities that you'll be conducting throughout the academic year under this particular session. Thank you. Thank you.
Yes. Thank you very much, sir, for addressing the session. Your words are always like a booster dose to us, and these are equally important as the protein supplement for everyone from the PCCOER family. Now, moving further, I would like to request Dr. Shyam Mankar, sir, to give the brief introduction about Pimpri Chinchwad College of Engineering and Research Institution Innovation Council sales details. Over to you, Dr. Shyam Mankar, sir.
Yes, sir. Thank you,
Yes.
Kishore, sir. Good afternoon, Ansika ma'am, then respected Principal Dr. Harish Tiwari, sir, and all the faculty members of IIC and PCCOER family, and the students from all the branches, all the discipline of PCCOER family. So I welcome you all for this first IIC activity. That is what is we are today we plan a session on IPR awareness and motivation by Advocate Ansika Bhardwaj ma'am. So just before that, I'm not taking much more time. So just I want to share the information regarding the what exactly the IIC means and what are the exactly the kind of the activities which we are looking under the IIC. I think my slide is visible.
Yes, sir.
Yes, sir.
Yes, sir.
Yes.
Yes. Okay. Thank you, sir. So I welcome you all again for this IPR awareness and the motivation session. So IIC is basically an institution innovation council, which is an initiative which is taken by a Ministry of Education and AICT in association with for the particularly related to the higher education institution. So as we know, this MOE, and under that, what we are considering that the MOE institution sale is actually systematically a platform which is provided by the AICT to the higher education institutes to encourage, inspire the students as well as the faculty members to work with the new idea and transform them into the prototype while they are in the coming recent years. So apart from that, again, when we are considering this IIC 3.0, it is actually an upgraded version of IIC 1 and IIC 2. IIC is actually a faculty experts student council, which will take a multiple activity to promote the innovation and entrepreneurships around the year, in particularly the higher engineering, institutes. Primary objective of IIC is to prepare the students with the skill like critical thinking, then design thinking and innovative thought process and the entrepreneurial mindset. Okay. So this is what the kind of the platform which is provided through the IIC or PCCOER for the students. So when we consider this particular the IIC 3.0, so it is having and some kind of the unique features as it is mentioned on the slide number 5. So semester-based approach for preparing and advising the annual calendar plan. So we already plan the different kinds of the activity for this first semester. So under that activity calendar is prepared, and again we are going to plan and conduct those activity. So as we all know, as we are associated with the PCET family and PCCOER, so we know that we are considering this all the 4 pillar philosophy of the PCCOER, whatever the different kinds of the discipline we have right from the first year. So just I will brief about that particular the 4 pillar philosophy, which is an academic excellence, then research and innovation, professional competence, and last one is the social commitment. So taking into consideration the whatever the guidelines and information from the IIC, so we are already in line with that, the whatever the kinds of the thought process behind the implementation of the IIC. If we consider the second pillar from the 4 pillar philosophy, that is the research and innovation, so we are in line that. Okay. So here at PCCOER, we have planned 3 different types of the activity under the IIC cell. So today's session of Ansika ma'am, it is the first activity about the IPR. So I again welcome you all the students, all the faculty members, then Ansika ma'am and respected principal sir for this session. So thank you all. Over to you, Kishore sir.
Thank you, Dr. Shyam Mankar sir, for briefing about the IIC cell of Pimpri Chinchwad College of Engineering and Research. Now, moving further, I request Mr. Sahil Salvi sir to introduce our today's keynote speaker. Over to you, Sahil sir.
Thank you so much, sir. So about madam has completed the master's degree in food science and technology in Pondicherry University. Also completed LLB in intellectual property law from University of Rajasthan. She worked in various national and international firms as a patent associate and law strategist. Currently, she is a founder of IPR Studio. Ma'am has completed expertise in patent preparation and its management, trademark application and registration, industrial design registration, copyright application and its registration. Ma'am have drafted a number of patent applications and design applications for a Fortune 500 companies, startups, entrepreneurs, inventors, non-profit organizations. Also, she well versed with patent drafting procedures and the patent law of India, Malaysia, Singapore, USA, and European nations. Ma'am, again we, Pimpri Chinchwad College of Engineering, welcome you. Now, I would like to request you, ma'am, to start this awaited session on IPR. Over to you, ma'am.
Thank you so much, sir. Hello, everybody. I'll be talking about IPRs today. So let me share my screen with you. Can you see my screen?
Yes, ma'am.
Is the presentation visible?
Yes.
Okay.
Yes, it is visible.
So today I'll be talking about basics of IPR. and the Indian patent system, as well as Indian trademark registration and copyright and design registration. So to begin with, let us come to know what is an IPR. So you might have heard about IPRs and everything, but still I'll give you a brief introduction about it. So basically, IPR stands for intellectual property rights, and IP stands for intellectual property. So basically, anything which has been created with minds are known as intellectual property, and rights given to protect such intellectual properties or creation of minds are called intellectual property rights. So basically, there are 5 types of IPRs. The intellectual property has been classified into 5 categories, that are patents, trademarks, copyrights, industrial designs, and geographical indications. So if we talk about patents, so generally a patent is an intellectual property which can be taken for a product or a process which gives you as an inventor an exclusive right to protect it and may protect it from others from using it, making it, or selling it. So basically, the only purpose of a patent is to protect your invention and have the authority over it. There, like, if I give you examples of patents includes a mobile or a robot or a computer system or anything. Or sometimes if you're developing a new process, so, and you want to protect that process, that is a novel process, then you have to apply for patents. So in India, in the patents are basically handled by Indian Patent Office. Indian Patent Office has 4 branches. One is in Delhi, Mumbai, Kolkata, and Chennai. So it depends upon the jurisdiction in which you are filing. As an applicant, if you are based in Pune, then your patent office would be Mumbai. For example, if somebody is filing a patent from Assam, for them the patent office will be the Kolkata patent office. So depending on the address of the applicant or the address of the service, the patent office is selected, and it is automatically selected while filing the application. If you are based in Pune, you will not select a patent office which is in Delhi. We will select which is in Mumbai. So after this, like if we are filing a patent, how do we know whether our invention is patentable or not? So there are 3 criteria which has been specified by the Indian Patent Act for a patent to be granted. The criteria include novelty, inventive step, and industrial applicability. So novelty means that the process or the product should be new. Inventive step means it is not just the product is just not new. It has something which we can call inventive, like it can do something, it is not obvious. And third is industrial applicability. If we are making a product that cannot be replicated on a wider scale, then it is not generally patentable. So a patented technology is for others also to get benefit of it, and you will earn royalty on it. You can sell the product like Apple. Apple has patented on their iPhones, but are being used by everybody. So that way they are also getting the benefit and the general public is also getting the benefit. That is the industrial applicability of an iPhone. The novelty and the inventive step varies from iPhone to iPhone. If you see iPhone 3 and now you see iPhone 12, we know how much difference they have created. So all those things are counted as inventive step. And if they have come up with a new camera, that is a novelty feature with them. So based on any of the features, they can take a patent. So the subject matter on which a patent is taken is known as a patentable subject matter. And there are certain conditions on which we cannot take a patent. Those are known as non-patentable subject matter. In India, non-patentable subject matter is generally classified under Section 3 of the Patent Act, which tells us about various innovations that cannot be patented. For example, the easiest of all, if I give you, a computer system is non-patentable in India. You cannot have a patent if you're developing a computer system. So under section I on K, it is not patentable. If you have a business ideas are also not patentable. Similarly, if we are making a new composition, we are just mixing 2-3 components. If you are making a food composition and already the ingredients are available in market, you're just mixing it and saying that you have developed a new product. That won't be counted as a patentable subject matter because you are just mixing 2-3 ingredients and developing a new product. So, section 3 talks about all these various non-patentable subject matters under which the patent office will not grant us a patent. And section 4 it also deals with non-patentable subject matter related to the atomic energy. If your invention is talking about or is related to atomic energy, then that patent, that application or that invention is not patentable. So it will be straight away rejected. So why do we need to know all these things? So whenever you are developing a new product or a process, say, you have to check for the 3 criteria. Along with that, you have to check whether your invention is falling under section 3 or 4. So if all these criteria are clear and you have a novelty, you have a well-established inventive step, you have industrial applicability, and your invention doesn't fall under section 3 and section 4, then only we proceed for patent filing. So while checking this, we also conduct a patentability search. Maybe you have heard about the term. What is a patentability search? So patentability search are basically, we check what all prior arts are related or what all documents are related to your invention or to your process or product. So we conduct a patent search where we see all the patents or the non-patent literature in order to know whether your invention or the product or a process has a novelty or an inventive step. So that is always recommended to conduct a patentability search before filing a patent application, then checking all the criteria of patent and the section 3 and 4, then only proceed for a patent. If all these things are not done, then there are chances of getting the patent rejected. So basically, this is all about non-patentable things. So in India, we can file 7 types of patent application. So if I say, if you have an idea in your mind about a product, but it is still in a developing stage and it is not complete, but you want to protect it so that nobody copies it, or you are presenting it in some seminar or a webinar, or you are discussing among your peers also, but you have a doubt that they might copy it, it is very inventive, it is very new, then you can always file a provisional application. So provisional application is just to establish priority and give us a timeline of 12 months to file a complete application. So what do we understand? This way we are protecting our invention, the inventive concept. If we are sharing with anybody and they try to copy it and file a patent, you will get the protection because you have a priority date of before. You have told the patent office that from this, suppose we are filing a provisional application today, from today onwards you will get a protection and you will get 12 months from today's time to file a complete application. So non-provisional application or complete application is one another the same thing. There are different words used for it. So non-provisional application is a complete application. There, whatever we have mentioned will be shown to the public, will be displayed in the public domain. And once we have added the information, we cannot change anything in that. So if you are in a developing stage of a product or a process, then go for a provisional application. Else we go for a complete application if our entire thing is ready. And the third is conventional application. So conventional application is basically when we are filing a patent in another country and then taking it to some other country. For example, I am filing a patent in US, then I want to enter India and file a patent in India. So when I'm filing a patent in India, the US patent office or US patent application acts as a conventional application. So we will get the protection in India from the date of filing of the US application. So the US becomes the conventional country and the USP2 application becomes the conventional applications. So whenever we are bringing it to India, we will file under the category a conventional application because it is already filed in some other country. It can be filed in multiple countries. We can have multiple priority dates and we can have multiple conventional applications. Then PCT. PCT applications are two types, international applications and national application. PCT is also an international application. For example, if in India, we are filing a PCT application, we are filing an Indian application, then we want to enter US. So there are two ways of entering any other country. Either we enter through a PCT method or we enter through a conventional method or Paris conventional method. In Paris conventional method, we get a timeline of 12 months to file in any of the conventional countries, but we have to amend and modify the patent application according to the patent procedure of that particular country. However, when we are filing a PCT application, a single application can be filed in multiple countries and we don't need any separate modifications to be done. Secondly, we get a timeline of 20 to 31 months to enter the country. It depends from country to country. If some application has to enter India, we have a timeline of 31 months. So if somebody is filing in 2020, they will get time till 2023. They will get exact 31 months to enter India. Similarly, if you want to enter US, the time duration is 29 months. From the date of filing, they will get 29 months to enter US. So once a PCT application enters the country, for example, in India, the PCT application has entered, then it is referred as a PCT national phase application. So PCT national phase application would be treated similarly as any non-provisional application is treated in India. So once it enters in India, it will be PCT national phase and it will have the same prosecution process like a non-provisional thing. It will go for examination, it will go for publication, and everything will happen like that. And if we are taking some application from India to another country, then it will be PCT international application. Then the sixth type of application is divisional application. So like I told you about the criteria, if the examiner comes to know or feels that the invention has more than one inventive step, then the examiner may tell at the time of examination to the applicant that he might divide the application into two or more applications depending upon how many inventive steps are there. One application can only have one inventive step. So that is how a divisional application works. And patent of addition. See, if you have gotten a patent or your patent is under process, while doing an R&D, you find out that some improvement or a modification can be applied to that product. So you can apply for a patent of addition in respect to the already applied non-provisional application. You will get the priority and the protection from the date of filing of the non-provisional application. So in and all, these are the 7 types of patent applications which are filed in India. So if we talk about the stages of patent in India. So in India, I told you the multiple type of patent applications which can be filed. So everything has a different duration. A conventional application can be filed within 12 months from the priority date or the date of filing. So the difference between date of filing and priority date is that the date from which we are filing the application is referred as a date of filing. But in case of a provisional application, the date on which the provisional application is filed is the priority date, becomes the priority date Or sometimes what happens, we are filing a provisional application and within 1 month or 2 months, we are filing the complete application. So in order to get the protection, we will take the date on which the provisional application is filed. And if an ordinary or a non-provisional application is filed, then the date of filing would be applicable. So once we have filed the patent application is filed in Form 1, that is the application form, and Form 2 is also filed at the time of filing, which tells about what type of specification we are filing, whether our specification is a provisional specification or a complete specification. So once we have filed Form 1 and Form 2, within 18 months, the patent application goes for publication. So in order to get the patent application published, we have to file Form 9 for an early publication, else we have to wait for 18 months to get it published. So it is entirely up to the applicant whether they want an early publication or they want to go with a normal process. So once the patent application is published, then the applicant or any interested party has to request for examination. So examination request can be filed within 48 months from the date of filing or priority date, whichever is earlier. And it is filed with Form 18 and Form 18A. Form 18A is for expedited examination and Form 18 is for normal examination. And request for examination is a mandatory process, for patent to be examined. If an applicant after publication or any time before 48 months does not file a request for examination, the examination of the patent application will not happen and the patent will not prosecute further. It will be considered abandoned by the applicant because the applicant has not filed the request of examination. So what happens once the application is published, if some other third party or any interested party feels that the patent which they're applying for is already known, is already there, or it is a copied version, they can file a pre-grant opposition for that. It is generally filed after publication and before the grant of opposition. Before the grant of the patent application. So pre-grant opposition is filed under Section 25 and in Form 7. So there, the opposing party will give a notice to the patent controller that he feels that the patent which has been published, the application which has been published is a copied one. He will give the grounds on which he is opposing it. So that same notice will go to the applicant. The applicant will give a counter reply to it, and then a hearing will happen with the examiner or the controller, and then they will settle down whether it will prosecute further or not. So if a pre-grant opposition is not happening, immediately after the publication, the examination is done, and once the examination is done by the controller, he issues an examination report, which is known as a first examination report. In the first examination report, the controller checks for all of the patent laws and the rules and see whether the patent application file abides to those laws and rules. And if he finds any discrepancy or any deviation, he will mention those as objections. And we have to file a reply to that FER within 6 months. And after that, once the reply is filed for the FER, the application, the reply, the FER reply is given to the examiner. The examiner goes through the reply. He may waive off certain objection based on our answers, or maybe he'll keep some of the objections. If whatever he feels is right, then he will call us for a hearing. And hearing is just a video conferencing with the examiner. Whatever queries and doubts he have, we have to explain him, give him a valid justification. Based on the hearing and the reply to the office action, the patent or application is either rejected or granted. Once it is granted, then we get a patent number and it is published in the Journal of the Patents. And then for 20 years we get a patent. So every 3 years, after 3 years, we have to give a renewal fees for that. And if somebody has to oppose after the grant of the patent, then that is known as a post-grant opposition. Anybody can oppose the patent, like on what grounds the examiner has given. Maybe they're not satisfied, or they feel that it is not new or something. They can oppose within 12 months from the grant of the patent. So this is the entire process how the patent application prosecutes in a patent office. Then if we talk about trademarks, like we have seen certain names or symbols where TM is written, or a R is written, or a C is written. So they have taken protection for that words, marks, symbols, or logos. So trademark is basically anything which is associated with a name or a company's name or a brand entity or identity, brand name, that are generally categorized under a trademark. So trademark can be taken for both goods and services. So, and there are various types of trademarks. If we see a word mark can be Google, a word mark can be McDonald's. If you see the McDonald's logo, M, and in below it is written McDonald's, it is together referred as a device mark, where we have a symbol, we have a written description, that is a device mark. Slogan, we can say like ICICI hum hai na, or thumbs up, where's the Josh. All these things come under slogans, and slogans can also be protected under trademarks. Then there are numbers like 4771, or if you're aware about 555. So all these, they have taken protection. 555 Cheney and whatever, or 1441 pizza, that is a number trademark. And logo is an Apple logo, or a BMW, or a Puma, where just we can identify from the logo which brand they're talking about. So trademark is generally to create a brand image in front of the customers, and how they can recollect your products or services based on the logo or based on the mark. So if we talk about trademark registration process, whenever a trademark application is filed in India, it goes through 6 to 7 steps. So the first step is conducted at before filing of the patent application, which is a trademark search. So in a trademark search, we will see in what category your mark falls. So generally there are 1 to 45 classes of trademark. 1 to 35 talks about goods, and 36 to 45 talks about services. So we will see whether your mark falls under good category or service categories, or both. So depending on that, you can file your trademark application in multiple classes. If your trademark is falling under a good class also and a service class also. So once the search is done, once the class is identified, we will conduct a trademark search. In a trademark search, we see what all similar marks have been registered, which is similar to your mark, or how can your mark can be new or may not be confusing with the already registered mark. So, and there you can go for, how can you go for a trademark registration? Once your mark is finalized, whether you're filing a device mark or a word mark or a number, based on that, we will file a trademark application in that particular class. So once the application is filed, it undergoes examination process. So it depends upon 2 to 6 months for examination of the trademark. So, and once the trademark is examined, the trademark registry issues a trademark examination report, and the applicant gets a time of 30 days to reply to that examination report. And once the examination report has been replied, it depends on the examiner to accept it or reject it. And once it is accepted, it can either directly go for publication or it may go for hearing. So it depends. If the examiner is 100% satisfied with your mark, with your examination reply, then he will just directly go for the publication. And if he has some doubts, he will conduct a hearing with you to discuss those matters and then either accept it or refuse it. So after that, once it is refused, you'll file a hearing and everything, and then it is either accepted or rejected depending on the hearing thing. So the trademark can also be opposed. It can be opposed after the registration or even in between the prosecution stage, it can be opposed. So once the trademark is opposed, it has a similar process like I told you in patents. The opposing party will give us a notice of opposition under TMO, which is the form for opposition. Then the applicant will file a counter statement. Then the counter statement will be sent to the opposing party. The opposing party will give some evidences to prove their point. Then the applicant will give his evidences to prove his point. Then a hearing will happen. Either after the hearing, the opposition is allowed or opposition is waived off and the application is granted. So that's how the trademark procedure works in India. So filing of the trademark application is generally done under TMA, which is the form for application. Then examination is done. Examination of the application can be done is done. So there are generally two types of objections if I talk about under Section 9 or Section 11. Section 9 is absolute grounds, or Section 11 is the distinctive grounds. So under Section 9, if we are using some common words or some common things, then the examiner objects on that. And under Section 11, he objects all the similar marks which are phonetically similar or visually similar to the applicant, so that the applicant can establish his point of novelty with respect to those already registered applications. So the trademark application or the trademark has to be visually different, has to be phonetically different, and has to be new. So you cannot create an image which may confuse the consumer. So your mark should not never ever confuse the consumer, else whatever mark you are trying to copy, that person can file an infringement against you and say that you are copying his mark as such. You are just confusing the consumers. You cannot use their color combinations and all. This is how a examination report looks like. If we see in this, the examination objection is raised under Section 11 and Section 9. Section 9 says that it is not distinctive, and Section 11 says that there are earlier marks which are identical or similar goods. So we have to reply in terms of these objections, and thereafter within 30 days, and thereafter the examiner will take it further. Either he will conduct a hearing for us or he will just directly grant the trademark. Once he is okay with the grant of the trademark, he will just publish in the journal. And sometimes if your mark is very unique and there are no similar marks available, the application, the trademark application will never go for the examination. It will be straight away published. So the publication happens in a journal of trademark, which is issued every last Friday of the month. And there we get a journal number, we get the trademark number, we get the page number where our mark has been published. And then once everything is done, it is published, there is no objection and everything, we get a registration certificate from the trademark registry, and the trademark will be valid for 10 years from the date of filing of the mark. So this is how a IP India interface looks like for a registered thing. So if we talk about the trademark they've applied was for televiz, and it was a word mark. So we know the category of mark, type of mark, and for what we have applied, and it is a registered mark. So we can check for the registration certificate, we can check for the application, we can check for the examination report. Everything is there in the public domain for anybody to access it. In case you want to oppose it, you think televiz is a very common word or is used by your company, similar mark is used by your company, and this particular proprietor is trying to copy your thing and confuse the consumer, we can file an opposition for that. And the renewal happens for the trademark after every 10 years. So now let's talk about copyrights. If you have any literary work or you have some paintings, photographs, music, films, sculptures, drawings, anything which you have created, which can be categorized under artistic work or a literary work, you can protect them under copyrights. So for the copyright registration, copyright registration is a very simple process. We apply for the application copyright, it is examined and the copyright is registered. So once we file an application, depending on you're filing a literary copyright or you're filing a copyright for your drawing, that would come under artistic copyright. As soon as we file it, we receive a diary number from the copyright registry. So we have to wait for at least a month, which is a mandatory period, to know whether there have been any objections filed or the copyright for which we are applying is open to everybody, so that if they want to object, they can object within 30 days. If the objection is filed, then the letter or the notice is given to both the parties, and the parties will give their set of replies with the evidences, with the statements and everything. Then the examiner will conduct a hearing for that, and based on the hearing, he will either accept the copyright registration thing or he reject it. And if there are no objections filed, then the examiner will search for himself. If he finds anything similar to it, he will issue a examination report, and then the examination report has a similar process, that the reply has to be filed from the applicant within 30 days. The hearing, after the reply, a hearing will be conducted. Based on the hearing, the registration will done or not. And if at the time of scrutinizing, if the examiner finds nothing similar or no objections, then he may directly register the copyright. So this is how the copyright registration is done in India. Now let's talk about industrial design. So industrial design is basically for an ornamental or an aesthetic aspect of an article. For example, if you have developed a machine and you want to protect the design of the machine, how it looks and everything, there you can apply for a design application. And if you're looking to protect the working of the machine, then you will go for a patent registration. So the appearance of the machine can be protected under design. So we can protect the appearances, we can protect the color, we can protect some patterns. If you see a toothbrush, a bendable toothbrush or an electric toothbrush, it has multiple pattern on it. If you want to protect that pattern, you can also file a design application. If you see a Lay's packet or any of the chips packet, so if you want to protect whatever is there on that packet, you will file a design application for that. So this way, an industrial design application is filed for a 3D feature, 2D feature, shape, outer appearance, or any of the aesthetic quality. If we talk about this example, the Motorola Razr phone, so they have taken the design application for the phone body. How the phone body can be closed and open, that they have taken the protection. So if we talk about the design application process in India, so once you have you have selected for which you have to apply for a design application, you will conduct a design class search. So like we have trademark classes, we have in design classes, IDCs they are known as, international design classes. And IDCs are based on international classification, so that all over the world we follow one classification only. So depending under which category your design is following, in that class you will register your design. For example, you have a medical device which is measuring a heart rate of a newborn, so you want to protect that, so it comes under medical category. So medical category is generally in class 24. Then we'll see we have certain subcategories. We'll see under what subcategory our design will fall. So it is basically a lab machine or a machine used in hospitals. For example, it is falling under subclass 2. So we would be filing a design application in class 24 subclass 2. Once the application is filed, we get the numbers and all, and while filing the application we have to create representation sheets. Representation sheets can have drawings, it can have snaps of your machine, it can have drawings, it can have the line diagram, it can be anything. Whatever way we can explain the examiner in terms of pictorial or diagrammatic way, we will make representation sheets based on that. Then we would be claiming whether we are claiming ornamental structure of it, or we are just claiming the shape and the configuration of it. That has to be mentioned in the representation sheet. And then the application is filed. We receive an application number and the application date. The design application then undergoes an examination process. Once the design applications are examined, if there is any objection, then a design examination report is issued. The applicant gets 6 months of time to reply to those examination report, and after that it will go under the hearing stage. After hearing, the application can be refused or accepted, and if there are no objections at the time of examination, then it straight away goes for acceptance of the design. So once the design application has been accepted, then it is notified in the design journal and the applicant is issued with the certificate of design. So this was all about IPR and how we file different types of IPR in India. What are different types of IPR? So this presentation covered everything.
Thank you, Anshika madam. Thank you for giving valuable information regarding patent, patentable and non-patentable subject matter, types of the patent, process of the patent filing, information regarding the trademarks and copyrights, and industrial design. So I request the students and faculty member, if you have any doubt, you can ask to ma'am.
Madam, one question is there.
Yes, sir.
Right now, Indian Patent Office made one amendment for academicians, especially in regard that charges, whatever be the fee structure for filing of patents.
Right.
So how, as a faculty or academician, how can I take the advantage of that? Is there any separate form I have to submit along with other forms?
No, when you are selecting the category of the applicant, you will be filing as a natural applicant and there you can, in the address of service, the name of your institution will come, and the fees, you can have multiple inventors or multiple applicants in them, and the fees would be, if I talk about form 1 for a patent, it would be 1600 only.
That is a regular fee, 1,600.
Yes, sir.
But now after amendment, I think it should be half.
No, sir. That is for earlier it was 8,000, 4,000. Then it was reduced. So 1,600 is the minimum fees anybody has to pay. It is the subsidized fees.
Okay.
Ma'am, I have one question. I'm Professor Jayashree Chopra from PCCOER.
Yes, ma'am.
Ma'am, in related to patent grant, you said that after granting a patent, we need to pay fee after every 3 years.
After every 2 years or 3 years.
So, can you tell you, ma'am, what will be the minimum cost for that? And if it is not paid, what will happen?
If it is not paid, then the patent will be removed from the patent journal. We get a time, like if it is 2 years, you get an extension. You can take an extension for another 6 months or 12 months, depending. And you have to file the fees. Then only they'll maintain that patent in the register. Else they will just cancel it. They will give you some intimations and everything, but then that will be cancelled if the fees is not paid.
It means only it will be removed from that particular journal, but it will be applicable for 20 years as per mentioned in granted certificate.
Once it is removed from the journal, then it is removed from everywhere. Because whatever is published in the journal will go into the Google patents and everything. So the Indian Patent Office maintains the register and everything once the fees is paid. So you can pay the fees cumulatively for all the 20 years also. But paying of the fees is a mandatory thing. We don't have any exception in that.
Okay, ma'am. Thank you.
Yes, anybody else?
Ma'am, there is a question, is there?
Yes, sir.
Suppose patent after the patent grant, so it is having and 20 years time is there.
Yes, sir.
Okay, so after that, it is we can consider it is a lapse or it is what abandoned.
Yes.
Okay, so can we use that particular the same patent along with for the some reference data or some modification purpose?
Reference data you can even use when it is in the process, it is not abandoned. But if you cannot use that patent as such. If you were taking that patent as a criteria and developing something new, that you can do. And when you are applying for a patent, you can give it as a prior art, that this was a prior art and this is the improvement we are doing. But exactly, you cannot just say that it has 4 elements and we are adding the 5th element and it becomes new. That way you cannot do.
Okay. Thank you, ma'am.
Ma'am, related to this, if I want to modify it, so is there necessary to mention whether I am modifying previous patent or not in new one?
It is not necessary, but whatever has been there in the internet is considered as a prior art for us. So irrespective whether that's a lapse patent or not, it will be a prior art. And the examiner will find out the prior art and your invention is 100% similar or 90% similar, then it would be very difficult for you to justify at the time of examination what is the novelty of it. If you don't mention it also, that is fine, but that will come out if it's similar, because we conduct a search based on the keywords of your invention. And that will be a prior art.
Thank you, ma'am. Thank you.
Okay, any question again? Okay, thank you, Anshika madam, for your valuable information regarding the patents, copyright, trademarks, and industrial design. So I think your presentation has cleared the idea about the concept, then process, and then information regarding this IPR. So
Sure, sir.
yes,
sorry to disturb you. There is a one question from Gayatri Satpute in the chat box.
Yeah, sir. Let me read this.
Please, sir, please.
Yes, ma'am. There is one question from Mrs. Gayatri Satpute. So, ma'am,
will combination of another brand of see what happens if you use color combination of other brand, that may create confusion in the minds of the consumer. So it depends on what brand colors you're copying, that brand can file an infringement against you, that you are trying to perceive consumers and from their thing to your thing. So that may be a problem. So we generally recommend not to claim colors. If you have a very unique mark, just go for the mark. So in future, you can use any color combinations. But adding, if we talk about Lays, the green packet of Lays, you are using the similar white, red, and green in the same proportion, same color, then it will be a problem for you, because that's PepsiCo is a big brand, and they will file an infringement for that.
Ma'am,
Yes, sir.
Yes, please.
patent is already invented, uh, but uh, but I want to invent something. Patent means
Hmm.
means I want to give an example. There is a Samsung phone and the
Hmm.
internal memory is 64 GB. But if I invented and the internal memory is 128 GB, would that be called as patent?
No. See, you are just changing the memory aspect. That is the external thing. If you're developing in Samsung thing, you're developing a new phone, then you can do that. Memory is just one feature of that phone. So whether it's 64 GB or it may be 1000 GB also, that is also protected under that. So it is very easy, or it is understood by a patent examiner or anybody that these ranges are not something. If you are developing something new in that range, will help you protect it. It will only protect only if you develop something new and inventive in that.
Ma'am, also there is one question.
Hmm.
Ma'am, I have thought about a patent,
Hmm.
but it has already been invented.
Hmm.
Uh, if if I change the internal design of it and but the use is same, would that be also called as patent or not?
See, if you are just talking about the internal design, go for a design patent. But if you're talking about the elements or working can be same. See, there are multiple ways to produce one thing. So the mechanism and the elements are different. You can always claim the different elements for the protection that you can do.
Okay, ma'am. Thank you, ma'am.
Yes, any questions from the student? Yes, ma'am. Thank you very much, ma'am, for clearing the concept
Hello,
about
ma'am.
the queries. Yes, Pratik,
Excuse
please.
me. Ma'am, I have
Yes.
and it has
I have
in
not
past
got
2 years.
any
So
mail
from
from
their
you.
side, what's the next process in that?
What have you applied for?
I have applied for the full patent, not the provisional patent.
Uh, okay. So 1 year has been passed now. Have you applied for
Yes.
Form 9? Form 9 was there for early publication?
No, ma'am. Form 9 was not there.
Then you have to wait for 18 months. After 18 months, your application will be published. And if you have applied for Form 18, then it's fine. And if you're not, after the application is published, you can apply for Form 18 and then proceed further for the
Yes.
examination. So you have to wait for 18 months.
Ma'am, I have done. I have submitted the drafting with along with the Form 18.
Then it's okay. Then once the application is published, it will automatically go for examination. But the examination, the publication will take 18 months because you have not filed for a early publication.
Then should I pay more fees for examination or any other process that?
No. You have already applied for Form 18. They have taken the fees from you. You don't have to pay any fees now.
Okay, ma'am. Then would they contact me or I have to contact them?
No, they will contact you. See, once it will be published, you will get the message and an email on the registered mail ID and the mobile number. And once your patent goes for examination, you will receive the notification of the examination report on the registered IDs.
And ma'am, where can I check the status of the patent?
IP India website.
Okay.
Okay, any query again? Okay. Okay, so before moving to the final session, I would like to request all the student participants to fill the feedback form which is available in the chat box, and for faculties, the feedback link will be shared on your official group. So for the final session, I would like to request Professor S.S. Bobde, convener IIC cell of Pimpri Chinchwad College of Engineering and Research, to present the vote of thanks.
Thank you, sir. A warm and graceful afternoon to our most valued honorable keynote speaker, Advocate Anshika Bharadwaj ma'am, visionary PCT management, honorable and beloved principal PCCOER, worthy teachers, my dear student friends, and everyone gathered here. It's my privilege to propose a vote of thanks and acknowledge the contribution of those who worked really hard to make this session happen. On behalf of Team IIC PCCOER, I extend a really hearty vote of thanks to our keynote speaker, Advocate Anshika Bharadwaj, IPR studio founder, patent attorney, and techno-legal expert, who spared time from her busiest schedule to grace the occasion. Today, we had an opportunity to hear your thoughts, and this will surely be going to encourage us in our future events. Your thoughts have enlightened our minds and have shown us a new path. My gratitude to all the attendees for gracing the session for their valuable presence. An event like this cannot happen overnight. The wheels start rolling weeks ago. The wheels start rolling means it requires planning and a bird eyes for details. We have been fortunate enough to be backed by Team IIC of very proactive and dedicated staff of our institute who are well versed in their job. A special mention to our respected principal, Dr. H.U. Tiwari sir, and President IIC, Dr. S.H. Mankar sir, for being the catalyst that stimulated us to do our best and standing as pillars of strength. With a deep sense of appreciation, we thank our loving teacher for their untiring efforts. Last but not the least, a big thank you to each and one of you who made this session so interactive. Thank you so much.
Okay, thank you everyone. So here I conclude the session. Thank you for making this event successful. Thank you, Anshika madam, and thank you all the delegates.
Thank you.
Thank you. Thank you all the students' participation. Thank you.
Thank you. And thank you, Bhavne sir, also for arranging such a nice session.
Yes, sir. Yes, sir. Thank you. Thank you all.
Yes, sir. Mankar sir also.